Something significant just took place inside the United States Supreme Court, and chances are you won't be hearing about it on tonight's news broadcast. Not because it lacks importance, and certainly not because it fails to affect you personally. The real reason is simpler and more troubling. The people responsible for informing you either haven't fully grasped what occurred, or they're waiting to figure out how to frame it in a way that benefits their particular side. And while that calculation is being made behind closed doors, while network producers debate whether this story helps or hurts their preferred narrative, you are left in the dark about something that directly shapes your vote, your state, and your most basic rights as an American. So allow me to walk you through it right now. No spin, no political agenda, and no condescending suggestion that this is too complex for an ordinary citizen to follow. Because it isn't. It's simply very uncomfortable for a great many powerful people on both ends of the political spectrum that you actually understand it. 9 justices recently came together and delivered a single, unanimous verdict on a question that goes to the very core of American democracy. Pause and let that sink in. In an era when the Supreme Court has transformed into a cultural battlefield, when every confirmation process becomes a fight for political survival, and justices are routinely accused of being party operatives wearing judicial robes, all 9 of them reached complete agreement. They did so on an emergency election case, whose consequences extend into every state, every election cycle, and every American's fundamental relationship with democratic self-governance. This was not some buried procedural footnote meaningful only to attorneys. It was a ruling about elections themselves, about who holds the authority to write the rules governing how Americans cast their votes, how those votes get tallied, and who ultimately ascends to power. The Supreme Court just answered that question, and they answered it as one. By the time you finish reading this, you will understand precisely what they declared and exactly why it reframes everything you believed you knew about how American elections actually function. To appreciate the true gravity of what the court just did, you first need to understand something about how the court itself operates, something most people overlook. Every year, the justices receive thousands of petitions from parties requesting that their cases be heard. The court accepts only a tiny fraction. The cases that make it through are, almost by definition, cases where something genuinely consequential is at stake, where lower courts have reached contradictory conclusions, or where a constitutional question has grown so urgent that it demands a definitive answer from the nation's highest judicial authority. Now layer on top of that already high threshold the concept of an emergency application. Under ordinary circumstances, a Supreme Court case is a years-long journey. A lawsuit begins in a federal district court, goes through months of discovery, receives a ruling, gets appealed to a regional circuit court, passes through a panel of 3 judges who review hundreds of pages of briefs and conduct oral arguments, and only after all of that can the losing party petition the Supreme Court. The court turns down more than 99% of such requests. If it does grant review, additional briefs are filed, oral arguments are scheduled months ahead, and the justices spend half a year composing and revising their opinions. The entire process frequently spans 2 to 3 years. An emergency application cuts through all of that entirely. It lands directly on the Supreme Court's emergency docket, sometimes within hours of a lower court's decision. There are no public arguments, legal briefs are thrown together under enormous pressure. The court must act with exceptional speed. Historically, this emergency pathway was reserved for the most extreme situations: a death row prisoner hours away from execution, a national security crisis with no time to spare. The fact that an election case arrived through this channel tells you something critical about the current state of American political stability. Whatever was being challenged was so close to taking effect, and its consequences so impossible to reverse, that the normal pace of judicial review would have meant permanent damage was already done before the court ever weighed in. Elections do not wait for litigation schedules. Once ballots are printed, once early voting opens, once results are certified, the political reality becomes fixed. Courts are deeply reluctant to unwind a completed election because doing so risks destabilizing civil order itself. Emergency action by the highest court in the land was therefore the only available mechanism to intervene before the system crossed a point of no return. And the court's willingness not only to take the case under a compressed timeline, but to rule unanimously, signals that all 9 justices believed the constitutional violation was serious enough and the risk of nationwide electoral chaos severe enough to demand their immediate and collective response. To understand where the court just drew its line, you need to understand the terrain that produced this ruling. American election law has always sat at a tension point between two competing constitutional values that have never been cleanly resolved. On one side stands the broad authority the Constitution grants to states over the management of their own elections. The framers made a deliberate choice to vest states with significant power to regulate the time, place, and manner of federal elections. This was not an oversight. It reflected a foundational decision about the division of authority between the federal government and the individual states. It explains why the experience of voting differs so dramatically depending on which side of a state border you stand on. In certain states, you may cast a mail ballot weeks in advance without offering any explanation. In others, you must appear in person on a designated Tuesday with a government-issued photo identification. For more than 2 centuries, this decentralized arrangement has been a defining characteristic of American democracy. On the other side of that tension sit the constitutional protections that belong to every American, regardless of geography. The Equal Protection Clause of the 14th Amendment does not dissolve at a state line. The Due Process Clause does not dissolve at a state line. The voting rights protections built into the constitutional architecture over the past century and a half do not dissolve at a state line. Every American, wherever they reside, possesses a floor of rights that no state may breach. When a state's election procedures fall below that floor, federal courts carry both the authority and the obligation to step in. The difficulty is that no one has ever fully agreed on exactly where that floor sits. And in the absence of consensus, what has occurred across election cycle after election cycle, accelerating sharply in recent years, is that the rules of elections have been altered, expanded, tightened, and overhauled through a mechanism the Constitution never actually authorized for that purpose. Governors have issued emergency orders modifying election procedures. State election officials have adjusted signature verification standards. Secretaries of state have expanded or reduced the availability of ballot drop boxes. Courts at various levels have rewritten the rules under the banner of emergency relief. And the essential point about all of those changes, whether they broadened access or restricted it, whether they were made in good faith or bad, whether they actually influenced outcomes or not, is that they were all made by individuals and institutions that the Constitution does not designate as the primary authority over election rules. Because under the constitutional design, that authority belongs to state legislatures, bodies that are themselves democratically accountable to the voters they represent. This is the legal fault line that has been fracturing and shifting beneath American election law for years. This ruling is the seismic event that the legal system had been building toward. Here is what the court actually said, and this is where the ruling becomes more consequential than the partisan reaction already forming around it. The heart of this decision is a clear, direct, and now unanimous affirmation of where primary authority over election rules resides under the American constitutional system. It resides in the legislature. Full stop. The practical meaning of this is profound, and it cuts in directions that are going to leave both sides of the political divide deeply uncomfortable in different ways. This ruling is a double-edged sword, and both edges are equally sharp. Consider the first edge. For states where executive officials or state courts have deployed emergency powers or expansive readings of state constitutions to broaden voting access, unilaterally extending mail ballot receipt deadlines past election night, waiving witness signature requirements, this ruling operates as an immediate and binding restriction. It makes explicit that those kinds of structural alterations, however well-intentioned, are constitutionally invalid unless formally enacted by the legislature. An executive branch cannot simply decide to reshape the mechanics of an election based on its own policy preferences or its reading of an emergency. If a state court rewrites established election procedures in the name of protecting voting rights, that court is now in violation of the federal constitutional framework. But examine the second edge, because this is where the ruling lands with equal weight on the opposing side. In several states, conservative executive officials or local administrators have attempted to use emergency actions or administrative directives to tighten voting access or impose new security measures, all outside the normal legislative process. Local election boards moving to unilaterally eliminate drop boxes. Aggressive new identification requirements imposed just weeks before an election, with the legislature bypassed entirely. The Supreme Court's ruling dismantles that approach with identical force. The underlying principle is genuinely nonpartisan. If broadening the rules requires an act of the legislature, then restricting the rules requires one too. An executive official cannot tighten election procedures close to an election any more than they can loosen them. The rules that exist, those duly passed through the constitutional legislative process, are the rules that govern. This effectively locks the existing framework in place as an election approaches, stripping both Democratic governors and Republican secretaries of state of the ability to manipulate electoral machinery through administrative maneuvering. The equal sharpness of both edges is, in fact, the strongest evidence that this ruling rests on genuine constitutional principle rather than partisan preference. The court is not telling you which party's preferred election rules are constitutionally sound. It is telling you which institution gets to make those rules. And the answer is the same, regardless of which direction those rules would move. Sophisticated observers of election law will immediately recognize a doctrine called the Purcell principle. This is where the legal depth of this ruling becomes apparent, because what the court has done is both build upon that doctrine and extend it in ways that will fundamentally reshape how every election-related lawsuit is litigated going forward. The Purcell principle takes its name from a 2006 Supreme Court case and holds one central proposition. Courts should be extremely reluctant to alter election rules close to an election. The reasoning is practical and sound. Late arriving rule changes confuse voters. Election officials scramble to implement procedures they were not prepared for. The potential for errors, inconsistencies, and outcomes that cannot be cleanly attributed to the genuine will of the voters rises sharply. Picture a football game in which the referee revises the scoring rules in the final quarter. Even if the adjustment is theoretically more equitable, the change itself undermines the integrity of the entire contest. But Purcell has always carried a significant vulnerability. It creates a perverse incentive. Parties or officials seeking to implement unconstitutional election rules are rewarded for doing so as close to an election as possible, because the nearer to election day the implementation occurs, the harder it becomes for courts to intervene without causing disruption. In other words, Purcell can paradoxically shield the very constitutional violations it was designed to prevent, simply because of when those violations are timed. What this new ruling does is confront that gap head-on. It does not discard Purcell. It incorporates Purcell's logic about the chaos caused by last-minute alterations, but adds something Purcell never contained: a clear answer to not just when changes can be made, but who is authorized to make them. By doing so, it equips lower courts with a more robust, more principled framework for evaluating election law challenges, one far more resistant to strategic manipulation through timing than Purcell alone could ever provide. The practical consequences for ongoing litigation are enormous. Across federal courts in this country, dozens of active election law cases are currently pending. Cases involving voter identification requirements, redistricting maps, registration deadlines, absentee ballot procedures, early voting availability, and poll worker training standards. Every one of those cases will now be examined through the lens of what the Supreme Court just declared. Every attorney working those cases is, at this moment, reading this opinion word by word, searching for language favorable to their client. Every federal judge with one of those cases on the docket is working through how this framework applies to the specific facts before them. This is the opening of a new chapter in election law, not a closing. A new chapter written under a framework that the highest court in the land has just unanimously established. Now bring all of this down from constitutional theory to the level that actually matters. Because every word of this ruling, every legal principle being applied and clarified and extended, ultimately comes down to one person: the American who sits at a kitchen table filling out a mail ballot, or who stands in line at a polling place trusting that their vote will be counted under rules that are fair, legitimate, and constitutionally grounded. What does this ruling mean for that person? It means that the rules governing the election they are participating in are supposed to be established by the institution the Constitution designates for that purpose. Not by executive decree, not by administrative improvisation, not by late-night judicial orders that change the game after people have already begun playing. By the legislature, by the body of elected representatives that the people themselves chose to make exactly these decisions. In a functioning democracy, that is not merely a technical legal requirement. It is a guarantee of legitimacy. When election rules are set by the legislature through a deliberate, transparent, publicly accountable process, voters know the rules before the contest begins. They can understand them, plan around them, and rely on them. When those rules are altered at the last minute by an executive official making a unilateral judgment call, or by a court issuing an emergency order, Even the most well-meaning change introduces precisely the kind of uncertainty that erodes public confidence in the process, regardless of whether the actual outcome was affected. One of the most serious crises in American democratic life at this moment is not the result of any particular election. It is the collapse of confidence in the process that produces those results. Tens of millions of Americans across the political spectrum have come to believe that the rules are being manipulated, that the system is being engineered, that the outcome they are participating in is not determined by the fair, neutral, pre-established application of agreed-upon rules. Whether that belief is accurate in any given instance, it is a devastating condition for a democracy to face. Democracy does not merely require accurate outcomes. It requires legitimate processes, and the legitimacy of any process depends enormously on the stability and predictability of its rules going in. What the Supreme Court has said unanimously is that the constitutional framework demands exactly that kind of stability. The rules must be established in advance, by the correct institution, through the correct process. No emergency, no administrative judgment, no judicial intervention dressed in the language of good intentions can substitute for that constitutional requirement. The implications for state governments are significant and will produce legislative and legal activity that remains visible and consequential for years to come. Every state will need to conduct a thorough legal review of its existing election procedures to assess whether those procedures are the product of legitimate legislative action or whether they were established through executive or administrative mechanisms that this ruling calls directly into question. That review is not optional. It is something state government attorneys will insist upon, because the alternative is leaving their state vulnerable to federal court challenges under the framework the Supreme Court has just laid out. For some states, that review will produce relatively little disruption. States with a comprehensive, legislatively enacted election code and a track record of preventing executive officials from improvising outside it, will find themselves on solid constitutional ground. For others, the review will be deeply uncomfortable. States where governors used pandemic emergency powers to substantially alter election procedures, changes that were never subsequently ratified by the legislature, will face serious questions about the constitutional legitimacy of those procedures. States where election administrators have accumulated a body of informal practice that was never formally codified into statute will be forced to choose between legislatively ratifying those practices or abandoning them. For state legislatures themselves, this ruling is simultaneously an empowerment and an obligation. An empowerment because the court has reaffirmed that the legislature is the primary authority on election rules. An obligation because that authority carries with it the responsibility to actually exercise it. A legislature that surrenders its constitutional role through passivity, that leaves gaps in the law inviting executive improvisation or judicial intervention, is not fulfilling the constitutional function the Supreme Court has just identified as uniquely its own. Step back from the specific legal details for a moment and consider what this ruling represents at the level of principle. American democracy has always been an experiment, not in the cynical sense of something expected to fail, but in the genuine sense of a deliberate attempt to apply certain governing principles to a large, complex, and diverse society, and to test whether those principles can sustain a stable, free, and self-governing republic. The founding generation understood this explicitly. They said so. The question they were attempting to answer had never been convincingly resolved by any prior civilization. Can human beings actually govern themselves? Can a free people, entrusted with the mechanisms of self-government, protect those mechanisms against the natural tendency of power to consolidate, to manipulate, and to corrupt the very rules that are supposed to contain it? That question is not resolved by any single ruling. It is not resolved by any single election. It is answered by the accumulation of countless decisions, large and small, made by institutions and by individuals across the full arc of the Republic's history. Every decision either reinforces the foundation or weakens it. Every time an institution acts within its constitutional authority, it affirms that the framework remains functional. Every time an institution exceeds its authority, even with the purest intentions, it chips away at that framework. And constitutional erosion is cumulative. Small breaches left unchallenged become precedents. Precedents become norms. Norms become the new baseline. And eventually you find that the framework bears little resemblance to what it was designed to be. What the Supreme Court has done with this ruling is arrest that erosion at a critical juncture. It has reaffirmed, unanimously, in an emergency posture that signals genuine urgency, that the constitutional architecture governing election rulemaking is not optional, not a guideline to be set aside when it proves inconvenient, and not something that good intentions can replace. That is not a minor thing. That is the court doing exactly what it was designed to do. Here is the essential takeaway, and absorb this carefully because it is the most important thing you can draw from everything covered here. A unanimous Supreme Court emergency ruling on the foundational machinery of elections is among the rarest and most consequential events that can occur in American constitutional law. And it just happened. The court reaffirmed that the authority to set the rules governing American elections belongs to state legislatures, not to governors acting on their own authority, not to election administrators exercising informal discretion, not to courts fashioning constitutional remedies under time pressure, to legislators, the elected representatives of the people. It extended and reinforced existing principles around the dangers of last-minute rule changes. And it did all of this in an emergency posture because something was already unfolding that could not wait for the normal pace of constitutional litigation. The implications reach into every state. They extend into every future election cycle. They reframe dozens of active federal cases that will be relitigated in light of what was just declared. They reach into state legislatures that must now examine their own procedures and determine whether those procedures rest on solid constitutional ground. And they reach into the life of every American voter who has ever wondered whether the election they are participating in is governed by rules that were set in advance by the right people through the right process. Whether you read this decision as a landmark affirmation of constitutional order or as a rigid constraint on adaptable voting access depends on where you stand. But what you cannot afford, regardless of your political perspective, is to remain uninformed about what the highest court in the land actually said and what it practically means for the future of your vote.